My name is Chris Noyes. I'm an inhabitant of the state of New Hampshire, currently living in Bethlehem. And one thing I wanted to add about Anna Marie's case, because she's been talking to me about it, is that there's also an affidavit that she didn't mention today, which was placed by the DCYF worker, which was clearly hearsay. The DCYF worker wrote an affidavit stating that the neighbor saw the child doing something or other. That in and of itself disqualifies an affidavit. Affidavit has to be firsthand knowledge. So if DCYF workers are in the practice of serving secondhand hearsay affidavits, that should let everybody know right off the bat that there's problems. And her child winds up being taken after the end of a process that started on a hearsay affidavit is all wrong. But I think it's important to talk about right now the impact that the New York Pistol and Rifle versus Bruin case has had on the way courts determine what a law means. So in the New York Pistol and Rifle case, the Supreme Court basically shifted the paradigm entirely from the what's called the two-step method for reviewing and determining what a law means, and they shifted to the one-step method. And in this method, what they do is they restrict themselves and confine themselves only to the founding generation's understanding of a law. So basically the first 50 years. And during that time, what we find is that there is no historical tradition during the founding generations for removing children from a home for going out to play, for instance. But more importantly, that impacts how you define what true due process is. So the definitions that were brought forward today are from middle American jurisprudence or recent American jurisprudence. And like I said, the Supreme Court has eschewed that. And you can hear the liberal Supreme Court justices actually complaining about that in the oral arguments of Rahimi versus US, where they're saying, are we now confined to only being able to look at the founding generation's understanding of the written law in order to determine the ruling in the case? And the finding was that yes, that's how it goes now since 22. So that basically takes the ACLU definitions of due process that you brought forward now, which are from recent history, and at a Supreme Court level, those would be tossed out. What would be considered the true due process is what Leah Cushman has brought forward before she was removed from the committee, which is a sworn affidavit, has to kick everything off. That has to be firsthand testimony. Secondly, the person needs to have a true trial by jury, which is different from a jury trial, and you should look into the difference. And it has to move exclusively by the rule of common law. No statute can be used. That is the true historical tradition of due process in America, and that's part of New Hampshire Constitution 115, which you all swore oath to uphold. Now, also as a result of this Bruin decision, courts confining themselves to the founding generation's understanding of how this country operates. I'm going to leave some evidence for you. But there was a gentleman at the Buffalo Law School, a scholar who did research on some 15,000 documents of all the writings of the framers and debaters of the constitutions. And what he found was that unanimously, every single one of them, whether Federalists or Anti-Federalists, believed that the constitutions were public trusts. And they said that the fiduciary duty of the trustees who swear oath to these public trusts, the penalty for breaching trust should be more severe than those the counterpart breaches and remedies and punishments available to the people in private trusts. So in private trusts, what's available to the people is, for trustees who breach, is litigation, arbitration, firing, and so on. Well, in the public trust, they added to those. Those were the bare minimum because they said the public trust breach should be more severe than the private trust. So they added to those impeachments, so on and so forth. But they never did away with the litigation, arbitration, and so on. And so just like the DCYS has to follow due process. When the people are planning to arbitrate or litigate their trustees, they need to follow due process. And one of the things they do is they provide notice. That's the first step, is the people provide notice to their trustees alleging that they are acting outside the trust, so on and so forth. And we give the trustees an opportunity to respond. We've sent you all notices here, and I think Sandy responded to one of them, but I don't think we've gotten responses from the rest of you. After that, we will proceed to giving an affidavit, just like due process, just like the government has to provide due process. We'll provide you due process, and we'll give you affidavits testifying to whether or not you have responded to our lawful notices. Now, unrebutted affidavits and uncontroverted affidavits must be accepted as truth by courts. And I'm going to leave you with 4 court cases proving that an unrebutted affidavit, uncontroverted affidavit, must be accepted as truth. So that brings me to the fact that we sent notice to DCYF back in October, telling them to produce evidence that they give true due process to the people, the New Hampshire 115 style that Leah Cushman has put on the record here, so plausible deniability has been removed, demanding them to produce evidence that they have given this true due process to anyone that they have put on a child endangerment list or terminated parental rights, and so on and so forth. We instructed Leah Cushman in that notice to follow up with them if they refuse to respond, to further investigate the matter. She did that, and the DCYF attorney basically responded saying summarily, we are within constitutional due process. Well, I hope that you can all see and agree that in a court of law, whether it be arbitration or a conventional court, I don't believe the judge is going to accept a summary statement from an attorney as sufficient and substantive evidence to overcome and controvert the claims made in the notices. Now, this week, several people here and in all the previous testimonies have sent affidavits into DCYF, and we sent affidavits into DCYF this week following up on their refusal to provide evidence. So when they fail to rebut or produce evidence to show you guys that they're giving the true constitutional due process, not ACLU's definition, the founding generation's definition, when they fail to do that, then you must take those uncontroverted affidavits as true, and you must assume that they are not giving true constitutional due process, which is a trial by jury, jury of your peers, where the jury gets to hear the facts and the law, because in a jury trial, the jury only hears the facts, and then they're instructed by the judge to follow the penalty prescribed in the statute. As Leah pointed out, the statute is not the law of the land, because the statute must hear before it condemns. Statute gives penalty inside the statute itself, so that cannot be the law of the land. The people have to be given a trial by jury of their peers, where the jury will hear the facts and the law, and they get to determine or nullify the law, actually, if they don't think it's a good law. Until the people get that and they can prove it. So what you guys have to do, what we're giving you lawful instructions to do today, is we want you to send notice to the DCYF and say, respond to the people, give them the last 6 months cases, they can give them to you. They can redact those personal information, names and addresses, that's sensitive. But you have to take a look at the process they're using and determine whether they are giving the founding generation's understanding of true due process before they ruin someone's reputation by putting them on a child endangerment list, before they take children, before they take money in parenting plans, all those kind of things. Anytime they do those things and they haven't given a trial by jury, moving by rule of common law, no statute, then they're violating the constitutional due process of the people. And that is an agency that was created by the legislature. So you have the authority and the responsibility to put a check on it, to put a stop on it. We want you to tell them if they don't produce this kind of evidence, then you want all the children, families reunited. You have the authority to give financial reparations. That's also in the historical tradition, and we can prove it that you can give financial reparations to the families that were harmed. We want you to take people's name off of child endangerment lists. All these people who have been railroaded by this entire system that does not give due process right from the start, you guys are the ones that are on the hook, the responsibility to fix it, because you created that agency, you have authority over that agency. It's your responsibility, and your plausible deniability is gone because we put it all out here. That's my testimony.
Thank you very much for your testimony.